They buried my life's work in dirt, 6,000 tons of it. And then, as if that weren't enough, they tried to send me a bill. My name's Caleb Mercer, 54, licensed blasting contractor, third-generation stone guy. And I spent most of my life learning how to make the earth cough up something beautiful. I thought I'd seen stubborn before, but suburban stubborn, organized, polite, and wearing polos taught me a new definition of crazy. I own an 8-acre limestone quarry about 20 minutes outside Blackidge, Tennessee, not some abandoned hole someone jokes about at a bar, not a backyard pond with a sad chain link. A state-permitted, inspected, bonded commercial site. 14 years of measured charges and careful benches diesel bills that made me wince, nights spent staring at loan statements until the numbers blurred. I chased one particular blue vein of limestone, architectural grade high, compression, the kind of stone that ends up as courthouse steps, custom fireplaces, and those Instagram outdoor kitchens people pretend they didn't finance with a second mortgage. That seam ain't inherited glamour, you earn it foot by foot with sweat and grit and a lot of patience. So I took a 5-week job up in Kentucky last spring. Good money. Union scale. And before I left, I did what I always do: walked the rim, checked the pumps, tarped the exposed seam against rain, locked the gate. I figured the quarry would be there when I got home. Instead, I came back to dust that smelled wrong. Red clay, like a farmer had upended his field and decided my quarry would be its mailbox. Where there should have been a 40-foot drop into clean-cut benches, there was flat, lumpy ground. Truck tire tracks and a gate with a busted lock. I walked out to the rim and my brain did that funny thing where it laughs at the impossible. I actually laughed and said, "Well, that ain't right." Then I walked the perimeter and counted tread patterns until my phone was burning a hole in my pocket. Next morning I went to the county clerk's office because big dumps leave paper trails, and sure enough, 39 dump tickets over 3 weeks. All under West Haven Estates. Homeowners Association, neat lawns, matching mailboxes, 50 shades of tasteful landscaping. They'd built up on the ridge about 6 years after my permit was on file. I remembered going to one of their early town halls trying to be neighborly, showing vibration studies, saying when we'd be blasting. Most people nodded, a few didn't. I called the HOA. A polite woman answered, then transferred me to the president, Douglas Harlan pressed polo, the kind of man who talks like he's chairing a committee, even when he's buying milk. Doug didn't stammer. He told me my pit was a safety concern, kids could get down, their property values might drop, and that they'd done me a favor by stabilizing the area. "We'll be sending you an invoice for $34,000, he said, smooth as a settlement offer. "It's only fair." He used the words, "we did you a favor," like a blessing. I stood in the middle of what used to be my blue seam and thought about the contracts I'd had on the books, the masons waiting on shipments, the deposits already spent on equipment payments. And then the certified letter arrived, accusing me of operating an illegal excavation without proper authorization. My hands still had red clay under the nails when I pulled out the one document I keep behind the tax returns, and my father's pocket watch, the mineral rights deed signed in 1963, stating the subsurface mineral rights to my 8 acres belonged to the Mercer family down to 400 feet with full protection under Tennessee mining law. Granddad bought those rights when the land was nothing but scrub and timber. He didn't have much, but he knew enough to protect what rock he could. I drove to Nashville and sat with Laura Bennett, sharp, efficient boots under her desk instead of heels. And when I told her the story, she didn't blink. "They filled an active permitted quarry without your consent," she said. "That's interference with mineral extraction. If it's willful, treble damages are on the table." Treble. My head did a slow nod. Suddenly I felt steady instead of furious, steady enough to plan something better than shouting into the phone. We filed with the Tennessee Board of Mineral Resources photos, dump records, permits, emails from early meetings where I'd offered extra fencing and a blasting schedule. 2 days later, a state inspector named Raymond Cole, gravel, voice, sunglasses, clipboard, stood at my gate, dug his boot into the fill, pulled out chunks of concrete, took core samples. He didn't need much convincing. He went up to West Haven's clubhouse, and by the end of the day, the county had issued an order to remove all foreign fill within 30 days at the HOA's expense, or the state steps in and recovers the cost. The mineral estate is dominant in lawful extraction matters. In plain English, my rock outranks their lawns. That should have been the end of it, you'd think, but the real story was just getting ugly. When the state contractors pulled the debris out the lab, results came back with a punch in the jaw. Clay pushed deep into fractures, petroleum from asphalt chunks, drywall particulate in the upper layers. The core samples said 2,400 tons of compromised stone, architectural grade, ruined. I did the math in my head and let the numbers land $360 a ton when the market's good, and suddenly the seam I'd worked 14 years for was worth almost 900 grand gone. Add loss contracts, excavation costs, assessment fees, downtime. The total climbed until my ears buzzed. West Haven's defense was predictable safety, environmental concern, misunderstanding, but lawyers don't win sympathy contests. They win on documents. And then, like a bad movie plot that lands as reality, Laura slid me an email from Doug, dated 3 weeks before the first dump. Caleb Mercer will be out of town for a month. This may be our window to resolve the Quarry issue decisively. Window. Premeditation wrapped in HOA stationery. That's when the idea of willful stopped being a legal theory and started to feel like betrayal. The hearing went 34 days. I didn't grandstand. The deeds, the permits, the dump tickets spoke. When the judge read the judgment, $6.9 million payable within 90 days, the gallery exhaled like someone let the air out of a bad balloon. Doug stared at the floor. The board looked white as paper, but a judge's ink isn't the same as a bank transfer, and I'd spent enough years around contractors to know judgments are promises until the money shows. What happens next is the part of the story that tastes like karma. And I don't say that lightly, because people got hurt on both sides, and a neighborhood unraveled. West Haven's insurance denied coverage, mining claims excluded, intentional acts excluded. Then the bills started going out to residents, special assessment being considered tens of thousands per household to satisfy a judgment their board had created. Meetings got ugly. There were families who bought into that subdivision on assumptions of stability and ended up fighting over bylaws they'd never read. By day 75, the HOA filed for Chapter 7. They liquidated assets, the clubhouse, the reserve fund. A trustee moved through the pieces. 2 weeks later, Doug filed personal bankruptcy. I heard he lost his house. You ever think about what justice looks like when it isn't cinematic? When it's not a triumphant soundtrack and a slow pan over a hero holding a check, sitting on the loading step of my excavator, grease still under my nails, watching the walls of the quarry clean and true again. That was it. We recut the seam, hauled the contaminated layer away as lower-grade aggregate for pennies, and corralled what was left. Over the next year, the market held steady, and we pulled about $2.4 million in clean stone out contracts, fulfilled new ones signed. It wasn't the same as what was lost, but it was work done right. There was this moment months later in a hardware store that I didn't expect. An older couple from West Haven recognized me, embarrassed, hesitant, and the husband said, "You were within your rights." That meant more than the judgment ever did. Because underneath the legalese and the bank accounts, there's a lesson that slapped me sideways. Power feels real when it's printed on HOA letterhead when committees vote, and minutes are taken, but ownership, real ownership, is what's etched in deeds and backed by law. If Doug had picked up the phone before those trucks rolled, if he'd wanted a conversation instead of a fait accompli, maybe none of it would have happened. I'd have reinforced fencing, scheduled blasts differently, maybe even helped with signage. I'm not unreasonable, I just don't like people deciding my livelihood for me. Do I feel satisfaction? Yeah, a little. I'm human. But the bigger feeling is the weight of how one decision framed as protecting families can ripple out and crush the structure of a whole neighborhood. There were likely kids sneaking near the fence. Blasts have rattled windows. Nobody wanted harm. But there's a difference between fixing a worry and taking somebody else's life's work and turning it into your landfill. I stood at the bottom of that quarry one night, lights humming, generators breathing, my crew ghosting along the benches, setting charges. We fired a blast that rolled clean and controlled through the walls and up toward the ridge where West Haven's houses sit in neat rows. I imagined curtains shifting, people pausing mid-conversation, and somewhere in the quiet, after knowing the law worked the way it was supposed to, rock doesn't gloat. It waits for the next charge. So here's what I've learned the hard way. Conflict doesn't start with explosions. It starts with assumptions. Assumptions about Who has authority assumptions that your fear gives you the right to act, assumptions that the end justifies the means. Laws are blunt instruments sometimes, but they exist because someone thought through what happens when neighbors don't talk and boards do. Boundaries matter, not just fences and signs, but the principle that you don't get to redraw someone else's line because you're scared or annoyed. Now, I want to ask you, and be honest, this is the part where I read more than you think. If you lived in that subdivision, would you have supported filling the pit? Would you have trusted the HOA to make that call for the community, or would you have demanded a conversation with the owner first? And if you were in my boots, staring at 6,000 tons of someone else's decision piled on top of your life's work, would you have pushed for every dollar the law allowed or tried to settle and spare your neighbors? Tell me what you think. Drop your thoughts in the comments. Tell me about a time a neighbor or a board crossed a line with you. Argue whether justice looked right in this case or not. I read everything. Because at the end of the day, this wasn't just about rock. It was about boundaries, pride, and what happens when a community decides it can redraw someone else's map. And trust me, lines and stone don't move easy. If you've got a story about fences, bylaws, or the time your neighbor solved a problem for you, I want to hear it. Share below.
Cảm ơn các bạn đã xem video.